Hello to those listening. This is the Free Speech. And this time, I want to talk about, can you make DNA evidence inadmissible in a court? And I say, yes, you can. But it has to be done in this very particular way that I've seen. You need to have a murder case. And during the evidentiary part of the trial, the defense attorney must come to oppose the prosecutor's presentation of DNA evidence. And this is where it all begins and actually ends. Because to counter the prosecutor's evidence, you must use evidence of your own. And you're using the evidence coming from places like the family court system with the argument that the courts have not actually come to a definitive conclusion about how DNA evidence should be used in a decision. Now, when you do this, you'll probably, be prepared for the judge and the prosecutor probably trying to keep themselves from laughing because DNA evidence. It's a scientific certainty. It's it's been used for decades now, but it won't take away from the argument of in the family court system, you have cases where men have presented DNA evidence saying they are not the child's father, but yet they are still held responsible, which means that the DNA evidence by the court's standards, and the court's supposed to have a universal standard when it comes to evidence, even though we may have different tiers of how much evidence is needed, the universalness of the evidence should not be in question. What we now have is a question of the DNA evidence through the court system, thanks to the courts. Now, as the argument continues, is if we have the court system and the family courts that will ignore DNA evidence and still hold them responsible, how can we then, in this courtroom, then say DNA evidence isn't total absolute? It doesn't work. Now, and the ramifications of those effects now become illegal actions, which comes down to every one of those men can now sue the federal government, the state government, counties, the entire child support industry, and maybe even get the prison systems. Because when the government takes their money for child support, that's theft. When the government, let's say, revokes a person's driver's license, well, you can call that not entrapment, but okay, the word escapes me. Maybe racketeering. You're probably coming to racketeering because what you're really doing is saying, "Give me money, or we take stuff away from you." And you have assault, they are arrested. You have kidnapping and false imprisonment charges. And because, again, the federal government helps fund these things along with the state and all the other agencies I've talked about, they all bear some responsibility. That's one. And then you have then you have the second side of, okay, it is not universally, it should not be, in other words, it's not a universal, shouldn't be not, now it's not a universal for decision making. Which is fine for, the family court system, but now it puts the criminal justice system in a little bit of hot water because now any person who's ever been put in prison because of DNA evidence can now have a very, very easy claim of a claim on appeal that they use DNA evidence. It's not a universal anymore, meaning that the prosecutor did not prove that the DNA evidence should be used, therefore it should have been thrown out. And now the criminal court system, which already can barely contain and hold the people at the levels at now, will probably have a massive influx of thousands or more trials to get through. Also not that great. Now, but there's also a third option. And the third option is will be a little bit more really pushing the limits of the Constitution if they can pull it off. And it would be that every individual court system gets to make its own rules. And this is why I say it's a little more fuzzy when it comes to the Constitution, because the Constitution is supposed to be more an overarching thing, but the minute you play that, okay, the family court system can ignore this evidence, but the criminal justice system can't ignore this evidence, and it's like, man, there's a little bit constitutionally there. So this is the reason I'm saying that, yeah, if done in this manner, you can challenge DNA evidence in the courtroom, and because nobody has ever really put too much thought into how to counter an argument like this, they would probably just have to dismiss the case to be refiled later on when they do come up with an argument against it. So, with that being said, this is the freest of speech. Thanks for listening.